the Supreme Court of Nigeria has affirmed the powers of the Economic and Financial Crimes Commission, the Independent Corrupt Practices and Other Related Offences Commission, and the Nigeria Financial Intelligence Unit to investigate and prosecute alleged crimes across federal, state, and local government levels. The Apex Court, in a judgment delivered by Justice Ogunye held that the acts establishing the anti-corruption agencies were lawfully made by the National Assembly, and that body is constitutionally empowered to make laws for the good governance of the entire country. The Attorney General of Kogi State had dragged the federal government to court to challenge the legality of the EFCC, ICPC, and NFIU acts on the grounds that they were not ratified by the State Houses of Assembly, having been an offshoot of the United Nations Convention on Corruption. Public interest lawyer Jiti Ogunye joins me again for the latest development. Jiti Ogunye, thank you very much for joining us on the program.
It's my pleasure, sir.
I recall that the last time this matter was still in perspective. You were here.
Yes,
you were saying, well, you don't want to say anything that will appear prejudicial. But now their lordships have decided that the EFCC, ICPC, NFIU are not illegal bodies and they were constitutionally created. Now, what is the significance of this?
The decision of the Supreme Court on this matter is very significant because it put paid to all controversies regarding the critical question of whether the EFCC was lawfully and constitutionally made. Before now, in many decisions, the Apex Court had ruled on various aspects of EFCC's powers and EFCC enforcement of other laws in the country, like the Money Laundering Act and so on and so forth, provision by provision and all that. For example, before now, the Supreme Court had ruled on whether it was necessary for the EFCC to obtain the fiat of the Attorney General of a state or the Federation before proceeding with prosecution, and that it's not in the mouth of a defense counsel or a defendant, a criminal defendant, to challenge the EFCC on that score, whether it had indeed obtained fiat. Before now, the Supreme Court had also interpreted Section 19 of the old Money Laundering Act regarding the burden of proof and the constitutional presumption of innocence under Section 35 of the Constitution. In one decision, the Supreme Court stated that the burden of proof could indeed shift, and that presumption of innocence could no longer hold regarding money laundering offenses. When somebody had some money in his account that is not proportionate with his means and income, the burden is on him to explain, and not for the prosecution to start explaining and all. The Supreme Court had made many decisions, but this latest decision is very significant because the EFCC was not a party. The Attorney General of the Federation was a party, and the Attorney Generals of all the states. So it's a constitutional issue. And before now, that question of whether the entire legislation of the EFCC, i.e. the EFCC Establishment Act 2004, was lawfully made and constitutionally valid, having regards to the provision of Section 12 of the Constitution, that issue had not before now been submitted to court for adjudication. And so I presume that was why there was so much controversy and furor over the subject. Now the Supreme Court has laid that issue to rest. And I think that the EFCC obviously has seen on the day of the judgment, was quite happy and satisfied with what is done. Now, we've not read in full the judgment. to be able to make a very informed and deep analysis of the judgment. But from the snippets of media coverage and reports, particularly regarding quotation from the judgment, one can at least say the following. One, before the court were two different arguments. The plaintiffs in the case, the number of states that went to the Supreme Court in that consolidated action argued that the EFCC Establishment Act was invalid, constitutionally invalid, because Section 12 of the Constitution provides clearly that if a treaty is to be domesticated in Nigeria, if a treaty is to be ratified and domesticated in Nigeria, a bill to that effect will be placed before the National Assembly, it will be passed, and then sent to the state. And a majority of the state, as a requirement, will have to sign up to it, adopt that bill, and accept it before it will be presented to the president for assent and enactment. Now, their argument was that this was not done in that case, and was even more. In an earlier decision in 2022, Nwobike and Federal Republic of Nigeria, the Supreme Court, in a judgment, leading judgment by Abubakar JSC, had stated, had accepted in a previous judgment that the EFCC Establishment Act was, as you said in your intro, an offshoot of UNCAC, United Nations Convention Against Corruption. Indeed, at the particular portion of the judgment, the Supreme Court accepted that that was the case. And so the plaintiffs in this instant case, instant judgment, pivoted on that by saying, if you, Supreme Court, had accepted that this is an offshoot of UNCAC, it's your decision. Then you must go the whole hog by ruling that since the EFCC Establishment Act didn't proceed from the provision provided by Section 12 as a convention that has been domesticated in Nigeria, then the EFCC Act would be...
That's
the question.
In the light of the current ruling, or the current judgment, does that Nwobike case, does it still stand as an authority, following the principle that the latest is the law?
Now, let me say that, you know this oft-quoted, Oliver Wendell Holmes, said that the prophecies of what the court will do, in fact, are not more pretentious, is what I mean by the law. So the law is as pronounced by the courts. And so whether the Supreme Court decided the Nwobike case by accepting that EFCC was an offshoot of UNCAC or not, the latest now is that the Supreme Court is saying that the EFCC Act was validly made. But what is important, and I think that we should dilate here a little, is that from what I have read, there was a portion where their lordships said in this latest judgment that there's a distinction between convention and treaty. There is only a treaty that will have to be domesticated via the route of Section 12, and the convention may not be so, with profound respect, that may not necessarily be so. There may be a distinction without a difference. Once you accept that it's a convention or treaty, you have to go via the route of Section 12. Otherwise, it would then mean, just as it was the case with the Child Rights Act, which proceeded from the Child Rights Convention, that the federal government would then legislate on its own, expecting the state to now legislate RAM. Because that's what was done in the Sharia Convention, which led to the Sharia Act. The Sharia Act was legislated by the federal government, enacted, but the states started, domesticating it in various states before 36 states and all that. Otherwise, what I presume happened in the Second Republic with the African Charter on Human and People's Rights Act, which was adopted as a treaty, as a charter in Banjul in 1981, before it was then domesticated in Nigeria. Indeed, the African Charter in Nigeria has the title African Charter on Human and People's Rights Ratification and Enforcement Act. Okay? And if you look at Section 12 of the 1979 Constitution as defunct, which is now defunct, it's the same provision, ipsis verbis, with Section 12 of the 1999 Constitution. But as I've said, the Supreme Court has ruled on it, and the Supreme Court gravitated in this judgment to say, under Section 4, 2 and 3 of the Constitution, if you look at item 60, item 67 and 68 of the exclusive legislative list, found in Part 1 of the second schedule to the Constitution, the federal government, the National Assembly, has the power to legislate. And then if you look at the provision of Section 15.5, the federal government of Nigeria, the state, has the right to fight corruption and abuse of power. And so, taken together, just as it did in the ICPC case, in Part 772 of the Nigerian Weekly Law Report, he said this is a good law and that law cannot be successfully assailed by the plaintiffs.
Okay, which takes me to an issue that may seem not to have been resolved. Some of the states in their filings had also said, look, part of the problem with these anti-corruption agencies is that we have a crisis of federalism. Some of the states, I don't remember the specific states now, were saying that, look, their right to set up their own independent anti-corruption agencies should be recognized, and that they do not have to be bound by the supranational imperial organs of the federal government, and that in any case, in reality, these anti-corruption agencies, they only target people that are not in the good books of the federal government. We've not seen what their lordship said in that regard. The constitutionality is so clear. But how about this concern about federalism, about the need for states to fight corruption on their own, and for nobody at the federal level to dictate to them?
My position on some of the judgments that have come out of the Supreme Court in recent time is that the court, as a policy court, is strengthening unitarism in Nigeria in the name of doing justice according to law. And I'm saying it with all sense of responsibility. I know that it's a valid argument for people to say, look, for system of government, let fools contend. What is best governed is best. We need an anti-corruption law. We need it to be very strong at the instance of the federal government, and that the states are only saying what they are saying, just as it is said in Yoruba language, an adage, and I will translate. When you see a cat doing a mischievous ablution in a corner, wringing his hands, it's just washing your pot of soup, so that once you lose attention or concentration, this say aluwala ologbo ogbon ati keran jeni. So look, the states are saying all this. I know that people will kick and say you are just saying this because you want to be reckless. You don't want to be guided. You don't want to, that's why you are now saying, oh, you are the new champions of federalism and all that. Yes, it can be a valid point, and it's unfortunate that because some of the states have been found to be reckless in the way, in their fiscal indiscipline, then what the Supreme Court is doing is always right. For example, the recent decision of the Supreme Court on local government autonomy and all that. What the Supreme Court did in that case was, there were clear provisions of the Constitution that provides that there shall be a joint account. That
Section 162 sub 5.
Exactly. Those provisions had not been amended. That's still the supreme law. But the Supreme Court, being this supreme determiner of what the law is, made its interpretation. And so those provisions still stick out there, while in effect, money will be channeled to the local government directly from the center. A committee was set up on implementation of the judgment, and so there will no longer be a joint state local government account into which those money
you are
should be
saying
paid.
in that particular regard, the Constitution needs to be amended?
Because the Supreme Court has said that this is the interpretation. Otherwise, those provisions will be there and will be at variance with the pronouncement of the Supreme Court on the subject. I'm using that as an example. That whereas earlier, when the federal government, the Olusegun Obasanjo administration, made a law called Local Government Statutory Allocation Monitoring Act, which was struck down by the Supreme Court on the ground that it was not consistent with federalism in Nigeria. What did the law provide? The law said, oh, this local government money is being stolen by the state. So there was a federal legislation, there was that law that provided, amongst others, that the Revenue Mobilization Allocation and Fiscal Commission, is a mouthful, should be saddled with the extra constitutional responsibility of monitoring statutory allocation to local governments so that the money would not be stolen, and that local governments and state governments are then required to be sending to that body reports of the expenditure. The matter went to the Supreme Court, and they split decision 4-3. 4 judges of the Supreme Court said, no, this is not consistent with federalism. Money that is sent down there, Revenue Mobilization and Allocation and Fiscal Commission, apart from the fact that being a constitutional body, a body created by the Constitution, cannot be extra constitutionally saddled with another responsibility. Outside the responsibility given it by the Constitution, this law, this act is anti-federalism. Now, if you compare that decision to the latest decision, there are 2 extremes. In that one is just monitoring. This one is saying, no, because we want to kill corruption at the local government level, at the state government level, we won't allow your money to be put in without. So if you then marry that decision to the latest decision, which is strong on anti-corruption, what you have is that we will need to rethink Nigerian federalism. People have argued that no, there is no standard definition of federalism. It depends on location to location and the political milieu and the environment and what you want. But from what we had in 1979, and now a lot has indeed happened. Recall that in 1979, the states used to have unlimited jurisdiction as far as the state high court is concerned. Then during the military era, the federal high court was packed with, powers. And so if you look at the 1999 Constitution, that unlimited jurisdiction vested earlier in the state government in 1979 is no longer there, and so on and so forth. So we're moving, farther and farther away from what we used to know as a federal arrangement. And so if you then have a political process, a political party or a government that says good governance, decentralization, and then by and by, it takes cases to court. We then, rather than decentralize, is centralizing, then we will need to, at a point, sit back and think through some of the things that we've been doing.
Okay. It's good that you have linked the issue of the constitutionality of the EFCC to local government financial autonomy.
Yeah.
Now, during the week, I think on Friday,
Yes.
this was the main subject of discussion at the 70th birthday anniversary symposium in honor of Pastor Tunde Bakare.
Okay.
And, you know, the guest keynote speaker was Professor Taiwo Oshipiton. And he raised these issues about how, look, that particular ruling by the Supreme Court raises further questions about federalism, about further amendments, about citizen activism. And, you know, he also looked at the dissenting judgment by Justice Abiru, you know, who had a different perspective, although in principle, both the lead, justice, and himself agreed on the same issue. Justice Agim presented the lead judgment in that particular case. In any case, let's go beyond law. Yesterday, your state, the people of your state went to the polls in 18 local governments. By this afternoon, we've been told that Ayedatiwa Orimisan Lucky has been elected governor for the next 4 years. Now, you are from Ondo State. What does that mean to you?
Well, it means a lot. Since 1999, the real question that has been asked and asked again is whether government, when elected and constituted, will work for the people. And yes, we can disagree on the issues, but I think that there's a general agreement that government has not worked for the people in the way and manner Nigerians expected.
Even in Ondo State? Across
the board. In the way and manner Nigerians expected. We were alive in 1999. Some of us were euphoric. You know, a lot of Nigerians, young people then, who are now middle-aged and old people, who thought that with the military's departure, it's El Dorado. You know, that problem will be so. And now we're still battling with power crisis. We're still battling with a lot of problems. And politicians will tell you that, oh, Rome is not built in a day. But there was no day Rome was not being built. The way we are going, this is like 25 years now, right? So where are we going to get the elusive dividends of democracy? And so let's stay on subject. You know, in those states, the way the election has turned is not surprising, because the balance of political forces in Nigeria is tilting towards, you know, the strengthening of the ruling party. The political competitiveness of the other political parties, you know, is not as strong as it used to be, and that will continue to impact. So that regardless of the state of the economy, you know, the state of misery, the state of poverty in the land, which ordinarily ought to be the driver of political angst and rejection, that will not impact much on the outcome of elections in the states that we are seeing. And so it's obvious that, you know, what had occurred in Ondo State will happen. The other political parties are not as strong. But that's being said, it's very interesting now that this governor that has been elected is going to serve one term because of the constitutional amendment, which provides that if you serve out the term of a governor that died or resigned, you know, you won't be able to get another re-election, so that you don't spend cumulatively more than 8 years, ultimately. So it's going to spend one term. And that can be a reason for recklessness, realizing that it's not going to come back, you know, to beg for the electorate for election again. And it can also be a reason for humility, sobriety, and, you know, incredible focus. So that, oh, I only have 4 years. I can't come back again. So let me do my utmost to ensure that the people are well served and well catered for. And in those states, such issues are there. In those south, we have ecological problem there. Ayotoro is been wiped off. So there should be dredging, reclamation of the shoreline and so on and so forth in the Bokoda area, in all those places. And then, there should be infrastructure development. There is no reason, a dual carriageway shouldn't run from Iwokoda or the southernmost part of Ondo State to Ayere, in the Ondo North Senatorial District and so on and so forth. Insecurity and banditry is a huge problem, particularly in the Akoko area, where I hail from Ikare and all those places, And there are a lot of community initiative, by retired professional generals, senior policemen, academics and all that, who have come together under a group called Akoko Peace and Development and Security Council that is helping to provide support to government. And I think that the state government will strengthen Amotekun. Now we don't have state police, and it's not a priority yet, and then ensure that there's security in those places, so that people in Norwalk, in Akoko and elsewhere can go to their farms, because I learned that people are not going to farm as they should go because of insecurity problem.
On that note, we would like to thank you very much. In his acceptance speech, Governor Aiyedatiwa says he was accepting the verdict of the people of Ondo State with gratitude and humility. Two key phrases.
Gratitude
and humility.
I didn't hear that, but now
how that plays out. And then we hope that he, coming from Ondo South, will take some of those your recommendations to heart. Thank you very much for joining us on This Day Live, the Sunday Talk Show.